Thank you. Good morning. Welcome to your North Carolina Court of Appeals. My name is Chris Dillon, Judge Chris Dillon. I'll be presiding today. To my right is Judge April Wood, and to my left is Judge Carolyn Thompson. We have two cases on the calendar today, and then the first case on the calendar is State versus McCord. And if the appellant is ready, you may begin. And you have 15 minutes aside. Let me know if you want to reserve some time for rebuttal.
Good morning. May it please the court, I'm Catherine Vandenberg from the Appellate Defender's Office, here representing Travis McCord. I'd like to reserve 3 minutes for rebuttal. In our court system, credibility determinations are made by fact finders based on live testimony, and our courts don't make credibility findings on a written record. This court regularly states it won't do so. And our case law, specifically State versus Bartlett, says trial courts can't do so when acting as fact finder. This issue has come up in a new context, but there's no reason to change the rule about credibility findings just because the setting is new. And Miller resentencing hearings involve one of the most severe punishments our court can impose in a criminal case. Only the death penalty is more severe. The stakes are high for these clients, and our courts should use great caution in ensuring that the outcomes of Miller hearings are fair and based on careful proceedings. If there are questions about the issue that you've pointed me to, I'm happy to start there.
What is the finding that the trial court judge made here that gives you heartburn in this case?
Well, the first one is paragraph 7, which is on record page 79. That's the main paragraph where the trial court talks about the credibility of the two women who testified at the original trial. And following that, as I've set out in the brief, many additional findings all throughout this Miller resentencing hearing rely on that version of facts that those witnesses gave. So paragraph 7 is the main one, and then it's all set out in the brief, the specific findings later that refer back to that original.
Well, when a judge is reviewing the record, and if you have two versions of facts, but they both point to the defendant's guilt, what's a judge supposed to do in determining whether or not life without parole is? Because doesn't a trial court judge do that anyway when there's whether to sentence the defendant at the top of a range for a crime or at the bottom of a range?
Well, if you're in structured sentencing, if you're looking within the presumptive category, that is true. The judge makes findings, but you know, Blakely and the United States Supreme Court have said that anything that aggravates the sentence has to be found by a jury beyond a reasonable doubt. And so North Carolina changed our procedure, and you know, the state now has to allege aggravating factors ahead of the trial, and there has to be a jury finding on those.
But if it's within the presumptive range, you don't need to make findings. And there is a range, a presumptive range.
In structured sentencing, that's true. But we're not in structured sentencing here, right? We're in Miller resentencing land, which is governed under different case law from the United States Supreme Court and a different statute.
In paragraph 7 that you point to, in this finding, the judge says that both Lankford and Sigmund gave testimony that was generally consistent with the testimony of other witnesses at trial and was consistent with the physical evidence and therefore found it to be factually true. Did the defendant testify in opposition to the testimony given by these individuals?
The defendant did not testify, but I disagree with what the trial court said there, and I've set that out in the brief.
But was there any evidence that was contrary to what all
Yes.
these
Well,
other
okay,
witnesses
so
said?
the physical evidence in the case didn't answer the question of who might have been the leader, right? The physical evidence, you know, there's no dispute about most of the facts of the crime, what happened. And the jury's verdict of guilty, you know, establishes, at least presumptively, I would think, that the elements of the crime were met. But the jury didn't make any finding, because they weren't asked to, at the original guilt phase trial about who might have been the leader, you know, what roles people played, all those sorts of things. And so when you get to the Miller resentencing hearing, And the state wants to make an issue of those. You know, most of these, I haven't seen this issue come up in any Miller case yet. But this is one where the state said, you know, we're going to go for proving that the 16-year-old was the leader of all the 20-year-olds in this case, and we're going to rely on written testimony from two women who were testifying at a trial in order to save their lives pursuant to a plea deal, and they're testifying co-defendants. You know, all of those factors should give the fact finder pause about believing them. And our system says you don't make credibility findings based on written testimony. So in this case, where the issue that the state was pushing at resentencing goes beyond what was decided at the original trial, that's what makes
So you're
it.
saying all that really was decided at the original trial was that this guy participated in the killing?
Correct.
But the reason this judge did not, gave him life without parole was because this judge found that he was the ringleader in this whole thing.
Correct.
And we don't, you can't tell from the jury verdict whether they made that determination.
No, that wasn't an issue, right? When you're doing a guilt phase trial, and also there was no sentencing proceeding then because there was only one punishment. So that just was never discussed in the original trial. And as I said, I haven't seen this come up in a Miller hearing before, but it came up in this case. And I also, as I said a minute ago, disagree with what the trial court here said in paragraph 7 about the physical evidence also supporting what the women said and the other testimony and other evidence in the case supporting what they said.
When the original trial, did the trial court judge have the discretion whether or not to give this defendant life with or without parole?
No. The trial was way before Miller. Yeah, this is a 26-year-old case. Right, so they didn't have sentencing hearings back before the Miller statute came along. You know, everybody guilty of first-degree murder got life without parole or capital. Right, so in this instance where the fact is material and where it's contested, in that situation, our common law requires that the fact finder make credibility determinations based on live testimony.
Well, you say it's contested, which is, we'll point back to my previous question. What evidence is in the record that is different than what the judge found? What can you point to? Because the defendant didn't testify, and all the other witnesses seem to corroborate each other.
Right.
So what is the contest here?
Right. The defendant didn't testify, but his statement came in. And his statement was, he was the first of the 4 co-defendants to give a statement. It didn't come in at trial because it was taken without parental consent and there was a motion to suppress. But it did come in at this hearing. And what Travis said at the time, 2 days after he was arrested was, we all did this together. We talked about what we were going to have to do. And part of his statement said that. And the other part was, Marquette Ruff told me to do this. Marquette Ruff told me to do that. So there's Travis's statement, which is contrary to what the women said. He said, we all agreed we were going to have to shoot her. And the women said, I didn't want to do that. He made me, right? That's a big conflict. And that's part of, the trial court talks about that a lot. And there's also the witness who testified called Tiny, who, the most neutral of them, I would say, because he wasn't charged. He just happened upon this scene. And Tiny's description of what happened at the hotel room was that Marquette Ruff was the person who first put a gun to him and said, I'm going to have to kill you because you've witnessed this, right? That's where that idea first appears. And, I talked more in the brief about what Tiny says. So Tiny's testimony and Travis's statement are contrary to what the 2 women said regarding who was in charge and who was running the show. I would also say that there are common sense inferences someone could make about a 16-year-old and a 23-year-old man. Marquette Ruff brought him to North Carolina. He was obviously an older person that Travis was following along with. Marquette Ruff was driving. We know about gang culture that often the older person makes the younger person do bad things, right? So these are inferences that could be drawn if all the evidence was put in front of a trial judge
So if he was an adult, there's nothing, it's a constitutional sentence to give somebody life without parole under the old statute, but except that he was a minor. So is there anything in Miller that instructs whether, that the judge cannot make these kind of calls, whether or not, in determining whether the crime reflects incorrigibility or whatever?
Right. Miller doesn't say anything about that. In fact, they say we're going to leave it to the states, how to make these calls. And they don't talk about, what kinds of evidence can be considered, except to say that you should be looking at everything and that the crime itself should not be the, primary driver of what the sentence is.
Well, under murder, like today, does the judge have discretion under the current statutes, sentencing statutes, whether to give a criminal defendant life with or without parole in some circumstances, or is that?
It is the judge's determination under the statutes.
The current statute?
Yeah,
right
which
now.
I would like to talk about, actually, so maybe.
Well, that's what I want to understand, because if the judge can do that today without, if the jury just finds the person guilty of first-degree murder and the judge just thinks, boy, that testimony was terrible, and I believe those witnesses, and can the judge in their discretion do that? Why is this different?
Well, if the judge has heard the trial, right, if you've just finished a trial and you've heard all that evidence, then a judge can make those credibility determinations. But the judge has to have been the person to hear the testimony under our common law. So I'm reading that in, yeah.
Okay.
And if you look at, if you can show, this is, I don't know if you can read it, and I have paper copies, but this is 15A 1340 19B, which is the statute that tells what the Miller procedure is for the hearing. And the state has said that subsection B here, the hearing, describing how the hearing goes, and the language is it shall be conducted by the trial judge as soon as practicable after the guilty verdict is returned. So that language, first of all, says by the trial judge, and obviously contemplates a current case, right? We've just had the trial, and the trial judge can then go ahead and make determinations like you just said. And then the next sentence, the state and defendant shall not be required to resubmit evidence presented during the trial, which is kind of saying the same thing. You don't have to put on all those same witnesses you just put on. And first of all, this statute was written very shortly after Miller was decided in 2012. And at that point, no one knew whether these hearings were going to be retroactive. In fact, the state was taking the position in every case that they weren't. And it wasn't until 2016 that the U.S. Supreme Court decided Montgomery versus Louisiana and said, yes, it is retroactive, right? So it looks to me like nobody was thinking about, well, wait a minute, what if it wasn't the trial court who heard the hearing in the first place? So I think we certainly should not be reading in the opposite result. This is suggesting, yeah, if you've heard the evidence already, we're not going to waste time repeating it, but you have to have heard the evidence to make these calls. Okay. If there's a credibility call to be made, which there may not. And I wanted to also show you the capital sentencing statute, and I put this in a memo of additional authority. And the framework is a little bit different in capital sentencing, and this court doesn't deal with capital cases much. You may not be that familiar, but it's a separate sentencing proceeding, right? You have a guilt phase, and then you have a sentencing phase. And in capital cases, there has to be a jury. But if you look at this language, it looks like they borrowed, when they wrote the Miller statute, they borrowed, right? It's the same. The proceeding shall be conducted by the trial judge before the trial jury as soon as practicable after the guilty verdict is returned. Very same language, except with the jury added in. Right. And they also say that in subsection 3, there's no requirement to resubmit evidence presented during the guilt phase. But in this subsection 3, unless a new jury is impaneled, right? So they, in that case, did imagine, well, wait a minute, what if one of the jurors gets sick, because we have the jury of 12 and the alternates and all that. And so there's a whole description about what happens in that instance. And they also talk about what if the person pled guilty, then what do you do for sentencing?
So our statute doesn't contemplate another judge conducting the Miller hearing?
It doesn't.
Okay.
And State versus Bartlett, which is the main case we're relying on, also involves, I think it's 15A977, which is about motions to suppress hearings. And that statute that Bartlett talked about, you know, in that case, there was a suppression hearing and there was a judge who made some oral findings that weren't complete. And then before that judge could do the written order, he was out of office. And so another judge came in and made the findings. And the court said, no, you have to be, to make the findings, you have to have been the person who saw the evidence. And
We'll give you a couple minutes.
Okay.
Save for rebuttal.
so but 977 likewise does not explain the negative. It just says the person who hears the motion to suppress should make findings. And it doesn't say, but if that person can't make the findings, then there must be another judge, right? And so but that is the rule under the common law, you know. And so my point is, because the Miller statute doesn't say that specifically, that doesn't mean that's not what they intend. So I'll leave it there for now. Thank you.
And I'll give you 2 minutes for rebuttal.
Good morning. May it please the court, my name is Heidi Williams. I'm here from the North Carolina Department of Justice. I represent the state in this matter. The question this court has directed the parties to address this morning is whether, in the context of a Miller resentencing hearing conducted decades after the defendant's original trial, the resentencing court erred by assessing the credibility of transcribed trial testimony to make a finding of fact under NCGS 15A1340 CA. The state asked this court to affirm the trial court's resentencing order here because the standard required to support a trial court's findings of fact in the context of a Miller resentencing hearing is the existence of competent evidence. In State versus Lovett, this court explained that it saw no reason in the context of Miller resentencings to depart from the body of case law, which has established that this court reviews challenged findings of fact only for competent evidence to support the finding. The state would submit that competent evidence certainly existed here. The trial court's challenged findings of fact.
But in the challenge here, the judge has discretion, but it sounds like what they're arguing is it's an abuse of discretion for the trial court to make credibility calls.
Your Honor, I would respond in 2 ways to that argument. First is that I think here the trial court, although it used the word credibility in its order, whether or not what the judge actually did here was a credibility determination, I think is a subject of debate. So the court certainly gave some credit to Langford's and Sigmund's testimony that was presented at trial, but the judge didn't do that based on any specific demeanor or the way that the witnesses testified. He didn't claim to have some special knowledge that gave them some credibility beyond simply comparing the testimony they gave with the testimony of other witnesses at trial, with the physical evidence that was presented by the prosecution at trial, and the court found that based on all of the witnesses' testimony, the record as a whole, that Sigmund and Langford's testimony was consistent with the testimony of other witnesses.
Well, was there any evidence that the defendant was not the ringleader, but just went along? Was there any evidence of that? Because she argued there was some evidence, and by the judge saying that, you know, I'm finding that he was a ringleader, isn't he making a credibility determination?
Your Honor, the state would submit that there was no evidence demonstrating, defendant did not present any evidence that he was not the ringleader. The one item of evidence that the defendant points to in his brief on appeal was the statement the defendant gave to police during the investigation, which was unsworn, not subject to cross-examination, in which he agreed, he in fact supported Langford and Sigmund's testimony in many ways, because he confirmed several of the circumstances of the crime. He simply didn't describe himself as a ringleader in his description of what occurred, but he certainly didn't, in that statement, characterize one of the other co-defendants as a ringleader in place of himself. So the state would submit that there is not evidence to support the defendant's claim that someone else besides him was the ringleader, and all of the evidence, particularly the evidence from Langford and Sigmund, supports the contrary was true.
Well, and is isn't it true that the judge didn't actually use the words ringleader? I mean, the judge said that the defendant exercised a position as a leader once the plan for robbery started developing. I mean, doesn't call him the ringleader that I could find in here.
Yeah, no, that's correct, Your Honor. I think the gist of the defense argument was just that the trial court's order painted defendant as being kind of a significant force that transformed the crimes here from being a simple armed robbery to then being a robbery that turned into a rape and then a first-degree murder of the victim.
Are there, I mean, every state's got this procedure because Miller was national. Have other states grappled with this particular issue or the federal courts that you know of?
Your Honor, that I am aware of, I am not aware of case law outside of this jurisdiction or from any jurisdiction that grapples with this particular issue of a judge at resentencing being forced to make a credibility determination. But again, I don't believe the court needs to reach that issue here because I don't think what the trial court did here must be construed as a credibility determination. And in any event, as the state argues in its brief, the state submits that the evidence here, there was no material conflict in the testimony of Sigmund and Langford with other evidence that was presented at trial or in the sentencing proceeding where this court even needs to reach that issue. So it may be the case that there, in a future circumstance, where at a Miller resentencing hearing, a judge is confronted with materially conflicting evidence and they have to make a judgment call between the two. That isn't the case that the judge was presented with here, given the strength of the evidence supporting defendant's guilt and the consistency of both the physical evidence, the evidence of other witnesses, and the consistency between Langford and Sigmund's testimony at trial. Unless the court has questions about that particular issue, I want to address defendant's argument that the statutory language does not permit the trial judge to make credibility determinations, again, assuming this court were to find that what the trial judge did here was in fact a credibility determination. The state submits that the statutory language in 15A, 1340, 19B supports the state's position that at a Miller resentencing hearing, a sentencing judge is not required to ask the parties to come and present all of the testimony from trial by live witnesses a second time. In fact, the statutory language specifically states that that is not required. In his reply brief, defendant's response to the state's argument was that basically the legislature, when it enacted the statute, didn't contemplate that Miller resentencing hearings would be occurring in kind of this post-conviction context where defendants were coming back years after the fact.
With a new judge.
With a new judge. And Your Honor, I would submit that that is absolutely not the case. The legislature certainly contemplated that probability, and we know that because the next statutory subsection, 15A 1340.19C, I don't know if this works. I do have the statutory language.
Did you help with that? I don't know. Yeah, there you got it.
I get it?
We got it. We see it.
So here's the statutory language from 19C, and in this subsection, I would first point out that 19C was also enacted in 2012 at the same time as 19B, and it belies defendants' claim that the legislature did not contemplate Miller resentencing hearings occurring in a post-conviction context. For example, in subsection B, the legislature specifically contemplates that defendants would be filing motions for appropriate relief or seeking relief under Miller after the time of their original trial and original sentencing. And subsection C puts in place specific procedures when the judge who presided over the trial is no longer available to act in the case, stating the senior resident court shall assign a judge who is empowered to act under subsection B of this section if the judge who presided over the original trial is no longer available. So given that the legislature in the immediately next section of the statute addressed these kinds of Miller resentencing proceedings happening well after, in a post-conviction context, when the defendant was originally sentenced, I think that discredits the defendant's claim that somehow language should be read into 19B of the statute to prevent the trial judge, a new trial judge who didn't preside over the original trial, from somehow being required to now try the case entirely anew before he or she may issue a ruling, issue a new sentencing judgment under the Miller resentencing statute. The state would also point out that defendant points to the capital sentencing statutes as a reason to say, well, in the capital sentencing context, when these kinds of occurrences happen, resentencing is required, you have to put on new live testimony if the jury who is impaneled is a new jury. The state would point this court to its opinion in State versus Lovett, however, where this court stated in clear terms that the capital sentencing statutes in North Carolina have absolutely no place in the analysis of the statutes under Miller. So in Lovett, this court stated, defendant engages in a comparison of the new sentencing statute with capital punishment statutory sentencing, citing 15A 2000, as the defendant here does today, and concludes that the new sentencing regime provides less guidance for the exercise of discretion in sentencing a minor in jeopardy of life imprisonment without parole. But our capital sentencing statutes have no application here, although there is some constitutional ground between adult capital sentencing and sentencing a juvenile to life imprisonment without parole. These similarities do not mean the United States Supreme Court has directed or even encouraged states to treat cases such as this under an adult capital sentencing scheme. So in essence, in Lovett, the court said that the interpretation of the juvenile statutes post-Miller and the capital sentencing scheme that our state legislature has imposed have no bearing on one another. So to the extent that defendant tries to argue, well, there is this live testimony requirement in the capital sentencing scheme, that is not found in the plain language of the post-Miller fixed statutes that are at issue here, and this court should reject any claim that those capital statutes somehow impose a live testimony requirement here.
Do we have a procedure, if there's a criminal trial going on and a judge halfway through the trial becomes unavailable, can you substitute judges during a trial?
I don't know the answer to that off the top of my head, Judge Dillon. I would be happy to submit a memo of additional authority looking that up, but I don't know off the top of my head.
I'm sure my colleagues probably can or not. You can't.
The state would encourage this court that accepting defendant's argument here that a trial court in the context of resentencing could not rely on sworn eyewitness testimony that was subject to cross-examination, accepted at least to some extent by the jury, that returned a guilty verdict against defendant, and which was supported by other physical evidence and other testimony in the record, and for which there was no material conflict with other evidence in the record. To say that that was not competent evidence to support a trial court's findings of fact at a sentencing hearing would be a dramatic departure from the deference appellate courts typically give to trial courts in rendering factual findings at resentencing. The state would ask this court to rule in this case that the trial judge did not exceed the bounds of its discretion in evaluating the merit of Langford and Sigmund's testimony, not based on any specific demeanor or some characteristic that was observable only to someone who observed their live testimony, but based on the other information in the record. The trial court's findings of fact were supported by competent evidence, and the state urges this court to affirm the defendant's sentence.
Thank you. You have 2 minutes.
Thank you. Regarding the trial court's use of the facts of its finding of the credibility of the two witnesses in paragraph 7, I'd just point you to the brief that I filed at pages 18 and 19 that goes through specifically where the trial court later used those, that initial finding. And there are more throughout the rest of the brief regarding each of the individual factors about maturity and age and that sort of thing. We haven't contended that the capital statute is governing anything here. I think the point that I was making is that you can't read into the plain language of the Miller statute an exception to the rule that there has to be a credibility finding made by someone who heard the evidence, and that's what the state's asking you to do. I want to remind the court about the testimony of co-defendants who are testifying pursuant to a plea deal and trying to reduce their own culpability. And in a capital case, there's no witness who's more suspect than someone in that position. And our state has a jury instruction about giving great care and caution to any person who's testifying in that situation. And that just adds, in my opinion, to the conflict and the credibility determination requirement for someone who's deciding an issue that wasn't already decided at the previous
Let me ask
trial.
you what I asked your colleague here. Was there did you look for any cases, or are there any cases around the country that have dealt with this issue?
So I saw a case, the Blakely jury findings beyond a reasonable doubt issue is out there. There are states who have passed statutes that say there has to be a hearing before a jury, and anything that is aggravating has to be found beyond a reasonable doubt by a jury. It's kind of all over the map.
But not on the Miller recall?
Yeah. Even in our state, it's a thorny issue about who even has the burden of proof. The statute doesn't say that. Our Supreme Court in State versus James interpreted the statute to say that you start off with equal opportunity, life with or life without parole, which hasn't been reviewed by federal courts and, in my opinion, doesn't comply with Miller, which says it has to be a very rare and unusual person to get. I would imagine you should start with life with, and then it's aggravating to get the few rare people like it is in capital. So that it's up in the air, is what I would say. We don't know what the burden of proof is for certain. We don't know what Miller requires in terms of any of that. I wanted to say one thing about the practical effect, which the state didn't argue this morning, but did argue in their brief, which is that I put in the memo of additional authorities, the McGirt versus Oklahoma case, just to make the point that it shouldn't matter to this court how many new hearings might have to be held in order to comply with our law. The object is to get the law right and let the courts deal with it as they need to. And if there have to be a lot of more resentencing hearings with live witnesses, then so be it. This is a really important issue, and certainly for Mr. McCord, the way the trial court made the findings has cost him any chance at freedom for the rest of his life. We'd ask the court to hold that the material credibility determinations made in Miller hearings must be made based on live testimony consistent with our case law. Thank you.
Thank you for your arguments. We will take it under advisement. Y'all need a break, or y'all okay? We'll go ahead and call the second case, and we'll give you a few minutes to get wrapped up here. The second case is Braswell v. Braswell.
I'd like to reserve 3 minutes for rebuttal. Good morning. My name is Lamar Armstrong. I represent the defendant appellant in this matter. And we get straight to the issue that Your Honors have asked us to address this morning, and that's venue waiver by filing a counterclaim under the Lending Tree 3-part test. And in particular, Part 2, the second factor, which is subsequent participation in litigation after my client, Mr. Braswell, filed a timely motion to transfer venue. And there's no dispute that his motion was timely. That's not a dispute.
Question real quick.
Yes, sir.
Just to start off, whether venue's been raised, is it true it's a question that we review de novo? I read one case that it was a question of fact that we review de novo or something. I mean,
So the question of waiver is de novo review. The question of whether venue is proper as an initial determination is not necessarily de novo, but that's not the issue before the court. The issue before the court of whether my client waived venue is a de novo review.
so that's a question of law.
Correct. Yes, sir. And so Going to the second factor of participation after filing a timely motion, Lending Tree, in Lending Tree, the defendant filed an answer and then engaged in discovery. And Lending Tree evaluated whether participation in discovery was a factor.
Filed an answer that.
Not the answer itself.
But filed an answer that asked for change of venue.
What the defendant did, it's not entirely, it doesn't spell it out specifically, but what the case says is that the defendant filed an answer which inter alia raised a motion to dismiss for improper venue. So that tells me that there was a substantive answer filed to the complaint, substantively responding to the allegations of the complaint, and then somewhere in the affirmative defenses raised a motion to, or somewhere in that answer raised a motion to dismiss.
In the response to pleading, they responded that.
Correct, and
But
it's
also
important to see that Lending Tree never says, aha, you responded to the complaint, there's an answer, and that's a factor that shows that you participated in the case. It doesn't say it's an important factor, it doesn't address it as a factor at all. It just goes straight to analyzing the participation in discovery after filing that answer. And so Lending Tree provides examples of what does constitute or could constitute participation under Factor 2, and those are things that you find in the opinion under North Carolina Reporter, page 410. It cites to the Yeldle versus Tutt case, and it says, as in that case, some things that could be participation under second factor include participating in discovery, filing various motions, participating in a 5-day trial, and filing post-trial motions, almost none of which, or really none of which, occurred here in this case.
Well, in this case, you filed a motion to change venue, but then filed an answer and a counterclaim and engaged in discovery prior to a hearing on the motion to change venue, isn't that right?
No, we did file a document that included a counterclaim after, and I'm going to show it to you in a minute just to go through the important points of it. Never participated in any discovery, not in this case. Never served any written discovery requests, interrogatories, never noticed any depositions in this case. So no discovery participation at all, which you contrast that with the discovery participation, which is what Lending Tree found significant. The big picture here, and we'll go right to the point. I'm going to show you what you find on record pages 79 through 86. And this is the document that on page 83, bottom of page 83 is where the counterclaim starts, but it's a single document that my client filed responding to the complaint after having previously already filed a motion to transfer venue. And so the question when we look at this document is, again, one of waiver. What is waiver? Waiver, as we all know, is an intentional relinquishment of a known right, okay? And Lending Tree says that you can impliedly waive your venue rights through actions or conduct. Those are the buzzwords, actions or conduct. But there's still got to be something in the record to evince an intent, an action or conduct that shows an intention to relinquish venue rights. And so looking at this document that the trial court found to be dispositive, at the very front of it, the very first thing that you see on page 79 is a motion to dismiss for improper venue, which again, there's already been a motion to transfer venue, but it raises the same underlying objection that venue's not proper in Wake County, it's proper elsewhere. So at the very beginning of the document where the counterclaim comes later is a reassertion of a venue objection.
And this was filed, I think, in June. Was the venue, is that correct? It was in June?
Yes, this was filed electronically June 13th.
So, but the venue, the prior motion for venue change was filed in May. Was that at the time this was filed, it was counted for July? Was it counted at this time? It had already been counted to be heard in July.
Correct.
So while they're waiting that, your client filed, y'all filed this.
Yeah, my client submitted a notice of hearing and calendar request 3 days after filing the motion to transfer venue, well before this was filed.
Which was in May?
Yes.
Okay. And then while they're waiting, and it was scheduled for July, but while they were waiting, you filed this, your client filed this.
Correct. And then if you look, so I showed you page 79, and then you go to page 81, and again, we're looking at this document in the lens of, is there something showing an intent to relinquish venue rights? And I, as a precaution, blotted out personal information. But response, and this is where the beginning of the answer to the complaint, which again, the answer in Lending Tree wasn't even mentioned as something that was relevant, but paragraph 1, this is responding to allegations that you can find on record page 5, which is in the complaint. But paragraphs 1 and 2, paragraph 1, my client admits that the plaintiff, appellee, Ms. Braswell, lives in Wayne County and has for 6 months, or at least lives in Wayne County as of the date of the complaint. And then paragraph 2, he admits that he's a resident of Johnston County. All right, and then you go to record page 83, and hopefully you can see the bottom of that, but that's where the counterclaim starts. The very first
concede this custody counterclaim was not compulsory, was it?
It-
Compulsory means if you don't bring it, you waive it. But he could have brought a custody action later. It's just the statute says that if you bring it, then you join it. So it's not.
It
it's not
is,
compulsory.
I'm sorry, I didn't mean to interrupt you.
No, I'm sorry. It's not compulsory in that regard. That he had
I
to
think
bring
it
or he
is
waived it.
compulsory in the sense that a compulsory counterclaim is one that has to be brought in the same case. It can't be filed as an independent action. And I think that's what Rule 13 of the Rules of Civil Procedure talks about when it talks about compulsory counterclaims. And this one has to be filed in this case because, as we cite in our brief, General Statute 50-13.5F says that when one of the spouses files a claim for alimony without divorce, that any claims for child custody or child support have to be filed in that same case. They can't be filed in a different case. And so whether my client filed his counterclaim for child custody in Wake County or Johnston County or anywhere else, it had to be filed in that same case by the statute.
But he still had time. I'm trying to figure out what was the rush. You had a window there. What was?
Well, the rush, I can't speak for trial counsel. What I can say is that the record shows that there was a heavy effort, and we go through this in detail in the facts and procedural history of our brief, but there was a heavy effort by the plaintiff to take discovery, to press for a hearing on child support, temporary child support.
Could have filed a motion to stay.
Do I know?
Could have filed a motion to stay.
Could have, but the standard under Lending Tree is not, did you do everything you could have done to avoid participation? The standard is, what active participation did you do that's sufficient to intentionally waive your venue rights?
But you couch it as just one document, but the document contained a motion to dismiss, a motion to strike, affirmative defensive, counterclaims. I mean, you set the tone that you're ready to go. You're ready for trial. You're ready to be heard.
Well, the tone is, we're ready to be heard on our claims in the proper venue. And there's nothing in this document that says that we believe Wake County is the proper venue. And so if you see the very first paragraph under the counterclaim, it says, again, that the plaintiff, my client there, is a resident of Johnston County and has been for more than 6 months. And then you go to the next page, record page 84, and it says, the defendant's a resident of Wayne County and has been for 6 months or more. And then paragraph 5 talks about how their child has resided her entire life at the residence in Princeton, which is Johnston County, before their separation. And then since, she's been residing in Wayne County and continuing to go to school in Johnston County. What's missing in all of that is Wake County. There's not a single fact that appellee can point to that says, here's a fact that shows that my client intended to waive venue, that he intended and he believes that venue in Wake County is proper.
So
and
would
that's the
venue
standard.
in Wayne County have been proper then, since one of the parties lived there? It would have been fine if she filed in Wayne County, just not okay if she filed in Wake County.
Potentially, yeah, under 1-82, but the motion to transfer was to Johnston County, which is also a proper venue under 1-82.
That's within the court's discretion as to whether or not to transfer venue to Wayne County or to Johnson County.
Well, actually, no. If venue is improper, and again, there's no debate here that venue was initially improper in Wake County. The only debate is whether my client waived the right to assert that. And so the law is, unless there has been a waiver, transfer is mandatory under 1-82 and 1-83, unless there's a waiver. But absent that, it's mandatory. It's not discretionary.
Is it mandatory to the county that the defendant seeks, or can the judge, to ask the question again, can the judge transfer to either county? That would be appropriate. It's mandatory to move it to an appropriate county, but does it have to be the appropriate county that the defendant seeks? Or is there any discretion there?
I think it's got to be in response to the motion that was filed. So I think that the motion was to transfer it to Johnson County. At some point, there was some argument that Wayne would be appropriate as well, but that wasn't what was before the trial court, is all I can say to that. Does Your Honors have any other questions before I move on to another, other than factor 2 under the analysis? So I'll wrap up by saying this. Factor 3, unnecessary delays, never been argued, so I think that's off the table. Factor 1, which is whether my client unambiguously raised and pursued his venue motion, it's clear that he unambiguously raised it. You can see it, it's in the record, and it's clear that that he pursued it. He never said anything, never filed anything withdrawing his calendar request, never stated anything on the record saying, never mind, I don't want to be heard on my venue motion. It was always...
And it was heard in July.
And it was heard July 12. The venue order wasn't entered until August, but it was heard on July 12th.
Thank you.
Thank you, Your Honors.
May it please the court. My name is Heather Forshee. I'm here on behalf of the plaintiff appellee, Loretta Braswell. At its core, the venue statute and the resulting case law are predicated on principles of fundamental fairness. The Lending Tree case makes it clear that even if a defendant properly raises a venue objection, they can waive it through their subsequent actions and conduct in the case. It also expressly acknowledges that defendants can waive a venue defense by participating in subsequent litigation, even when the defense has been timely raised. There are 3 key points in the matter before the court. First, that the court does not have to find all of the factors under Lending Tree to find that there has been a waiver. Secondly, that in this case, the filing of the counterclaim goes to 2 of the factors, and that is the creation of ambiguity with respect to the pursuit of the venue objection and active participation in the litigation. Third, that there was a later voluntary dismissal of the custody counterclaim that was ineffective when it was filed because the plaintiff at that point had already filed cross-claims for temporary and permanent child custody as noted in the record. Now, one crucial fact that was not clarified in defendant's brief is that plaintiff filed a reply to the counterclaim and cross-claims for temporary and permanent child custody and attorney's fees on June 14th, after the custody claim was filed by defendant in Wake County. And so at that time, it was referred to in defendant appellant's brief as a response generally, but that document was much more than a response. It was a response, it was a reply to the counterclaim, and it also asserted cross-claims for temporary and permanent child custody. The reply brief also indicated that neither party had taken any action to set the custody matter for hearing in Wake County, and that is actually not supported by the record. In the record, it shows that we did submit the required affidavit of judicial assignment and notice of hearing to the court when those claims were filed, and the court set the temporary custody case for August 8th in conjunction with some other claims that were then pending.
But you'd agree, our review, it's a de novo review whether or not the defendant waived his right to challenge venue. Is that correct?
Yes, I agree it's a de novo review as to whether defendant waived his venue right, and so that is one of the other arguments that was made in the brief. Obviously, at the trial court level, I did focus very heavily on the active participation in the litigation factor, and that is the factor that the trial court found most compelling.
Well, the defendant filed a motion to change venue, and it was scheduled for July, and he just chose not to sit idly by waiting. He went ahead and proceeded, but how did he what action did he take to waive it if he still, you still have that scheduled hearing, he showed up at the hearing and they argued it?
So I think in this case, the custody counterclaim goes way beyond limited participation in the proceedings. And so our courts have defined seeking affirmative relief as a defendant seeking relief for which defendant might maintain an action independently of the plaintiff, and where he can proceed to recovery on that, although plaintiff completely abandons their cause of action. And that is something that was argued at the trial court, that at that point procedurally, even if the court had dismissed plaintiff's complaint, or even if we had dismissed all the claims, defendant was essentially the plaintiff for purposes of that child custody claim, and that action would have survived. And then we filed our own cross claims for custody. I think the other issue with the timing of the
Because you're saying it's not a compulsory counterclaim then?
it was completely permissive counterclaim. And we would contest all of the reasons that they've tried to proffer to the court as to why it had to be filed then. It absolutely did not have to be filed then.
It could have been filed later as a motion in the cause, couldn't it have?
That is correct. And also under the protections afforded by Rule 12, there was no reason for any answer to be filed. So under the case law that examines venue waiver, there are two options for how a defendant can raise this defense. One is to go ahead before a responsive pleading is filed and assert the defense, which is what was done in this case. Or what they can do is wait till the time their responsive pleading needs to be filed, and in the answer that they filed, they can assert their defenses and affirmative defenses, including venue.
Could he have filed a custody action in another county and the result would have been just been joined with this one?
Yes, Your Honor, I believe that's correct. And so under 50-13.5F, there's a provision of that expressly contemplates that. And it says under subsection F in the venue statute that if there's another action subsequently instituted in the same or other county, that the court having jurisdiction in the prior action or proceeding may in its discretion consolidate it with the subsequent action. And so I think that was absolutely an option, but I think the reality in this case is there was no reason that the defendant needed to do anything at the time that he did. And so if we look at the factors...
I don't know who had custody of the children at the time, but the father might want to have custody sooner than later, didn't want to wait. I mean, that would be a reason in my mind. I mean, if the mother had custody at the time, I think the father wants to get that resolved as soon as possible.
Well, I understand that, Your Honor, and what I would say to that is if he did not want to waive his venue objection, he should not have filed for affirmative relief and engaged further in the forum that he said was improper. Yes, Your Honor, he should have filed in Johnston County, and I think that option was always available and on the table. I mean, I think if you look further into some of the facts that are in the record, one of the things that happens later on in the case is that there's a motion to continue filed on August the 2nd of 2023, and it says the court doesn't need to hear this matter, but there's no urgency to the custody claim because defendant hasn't tried to see the child. And so I think that's inconsistent with the factual assertions now that it was very important that defendant have this custody action pending so that he could pursue his custody claim. It's refuted by their own statements in other parts of the record. And I would say as to the lending tree factors, I think there's two factors that are applicable. One is the failure to unambiguously raise and pursue the venue objection. And so I think for that, again, he took an action that he didn't have to take in the litigation. And again, this was set for timely adjudication on July 12th. And so there was no need for him to take that action at the time he did. I would also say that under lending tree, what they found ambiguous was that venue had been stipulated to in a case management report where the parties had essentially checked a box that venue was proper. It was not an affirmative action or a pleading that the defendant himself had asserted himself voluntarily to the jurisdiction of that court. And so the present case, we contend that the child custody counterclaim that was filed, that is more than enough to create ambiguity as to the pursuit of the venue objection. And then participation in litigation, we still contend that that is the strongest factor before the court. In lending tree, what happened is defendant filed an answer, which defendants can do. The defendant did not file any counterclaims with his answer, and he noticed two depositions that actually never happened and served some written discovery that was delayed by a stay. And so in this case, the custody counterclaim goes way beyond some limited discovery participation.
Let's assume we hold that he did not waive venue. What happens when it goes back? Does it automatically have to go is the judge required to send it to Johnson County, or does the judge have discretion?
Your Honor, I think, like appellant's attorney said, the request to change venue was made specifically to Johnston County. Now, interestingly, we did have some oral argument on the record on July 12th where there was a stipulation that if it was going to be transferred, it would go to Wayne County, but I don't know if under our case law that would be binding, because the request and the pleading was for it to go to Johnston. And so we would contend that both of those factors under Lending Tree support waiver in this case. And again, our courts are defining affirmative relief as relief for which a defendant can maintain an action independently of plaintiff's claim and on which he can proceed to recovery. So our argument is, regardless of whether he reasserted a venue defense that he didn't need to assert at the time he did it, he still took an affirmative action to submit himself voluntarily to the Wake County District Court. And any subsequent actions that would have been taken to dismiss plaintiff's claim at that point would not have eradicated that claim. I will mention a couple of factual things that I think are important to the court's analysis in this case. I think the timing of the filing and the nature of the filing really goes to the heart of the waiver argument in this case. And that is, at the time that he filed that responsive pleading on June 13th of 2023, he had absolutely no reason to do so. We had a hearing scheduled for July 12th where he could have had his venue hearing heard, and under the protections afforded by Rule 12, even if he wasn't successful on that, he still had 20 days after that to file a responsive pleading. And so, again, the case law says you file your motion to defend against venue, or you file your responsive pleading and join the motion with that pleading. You do one or the other. You don't do both. So I think in this case, the fact that the defendant went out of his way to engage with the forum that he was objecting to, it did not make any sense at all. I think it created ambiguity, and it was active participation. And again, if you look at some of the specific allegations in this custody complaint that was proffered as an exhibit that's in the record, I think it's very telling that this was not the intention to assert just a boilerplate claim to preserve defendant's position in the already existing lawsuit. There are very specific allegations in there that plaintiff doesn't function as a homemaker, that she needs to get a job, that she doesn't provide any real assistance with the education of the child, and that she suffers from depression and spends an inordinate amount of time listening to prophets during the day rather than actually interacting or assisting the child with her homework or activities. These are not the allegations of someone trying to file a boilerplate claim just to get their foot in the door and preserve it. The prayer for relief that was made to the court was not only for joint legal and physical custody of the child, but it also asked for the court to order the parties to participate in family therapy and to order plaintiff to participate in individual therapy. So I don't think that under any liberal assessment of whether this was intended to be a waiver or not, that you can argue, well, I was just trying to put my boilerplate claim out there to preserve my right to maybe seek custody within this action. And again, didn't have to be filed when it was. I think it's important that while the Lending Tree case, it did analyze all three of the factors, and in the Lending Tree case, delay was probably the strongest factor. Lending Tree did not establish a bright line rule. It established a totality of the circumstances argument where the court evaluates the strength of each of those individual factors and weighs them, and then the trial court decides what weight to give to those considerations. And I think in this case, yes, we agree that defendant did not delay raising the venue objection, but that is what makes his subsequent active participation in the litigation even stronger as a factor.
We de novo weigh the factors too, is that correct?
Yes, Your Honor, that is correct. And so that was one of the things that had been argued in defendant appellant's brief, is that because we had focused pretty heavily on the active participation factor, that was what the court was limited to. And so that would be, I mean, we would contend that we did focus on that, but we did not concede that the ambiguity factor does not apply. And certainly on a de novo review, it's up to the court to weigh the factors and determine whether it's strong enough. Again, we disagree with the argument that the child custody claim had to be filed for any reason at all. And I will also note that defendant dismissed his child custody claim on July 14th, which was 2 days after we had oral argument on the venue issue. And again, stated in there, defendant has not attempted to see the minor child, and therefore there is no urgency to the custody matter. And that's on page 224 of the record. And so I think to make an argument to the appellate court that it was very, very important to get this custody claim pending, that's just not supported. The actions that were taken in this case do not in any way align with someone who had to file a custody claim at the time in Wake County. And so I think the issue before the court was an explicit voluntary action to file a claim, and that did effectively constitute waiver. And Your Honors, I'll just say it's clear in the other actions documented in the record, which I understand are not before the court today, that this was a case where the defendant wanted to use the litigation process to his advantage, but at the same time foreclosed the plaintiff from doing anything by raising the roadblock of venue. And this is exactly the kind of conduct that Lending Tree and our case laws say is not okay. Defendants have a right to lodge and pursue a venue objection. Yes, they do, that's clear. But if the defendant engages in certain conduct, it constitutes a waiver because our courts have recognized defendants can't use it as a shield and a sword. They can't use the litigation process in a manner to advance their own legal interest while also shutting down the plaintiff and taking a position that plaintiff can't do anything because of their venue objection. The conduct that's happened here in this case, that's exactly the kind of conduct that Lending Tree and the waiver jurisprudence has said is not okay. What Lending Tree said is that the factors are judged on their individual and their cumulative strength under a totality of the circumstances analysis, and that's acknowledged in defendant appellant's own brief. We contend that the custody counterclaim filed by defendant in this case was strong enough on its own as a factor of active participation in the litigation and the creation of ambiguity under Lending Tree. Thank you, Your Honors.
Thank you for your argument. Rebuttal?
Your Honors, there's been a lot of argument and bandwidth devoted to did my client have to file a counterclaim or not. But we're here at the end of the day to address Lending Tree and how this case fits in Lending Tree. There's nothing in Lending Tree that says filing a pleading in and of itself is a basis to waive venue, or could be. Lending Tree just talks about what happens after you file a pleading, and participation in discovery, participating in trial, that sort of delay in hearing your venue motion after you file it. None of that exists here, not a single thing. There has to be some action or conduct that evinces an intent to waive. The only thing that's been pointed to is the filing of a counterclaim. That's it. And not even looking at the counterclaim to see what it says, just the fact that it was filed.
But by filing the counterclaim for custody in Wake County, even if the plaintiff's complaint was dismissed, the counterclaim could still stand.
Sure, in Johnston County, just as good as it could Wake County.
But it was filed in Wake County. So is it that your client submitting himself to the jurisdiction of Wake County, at least as it pertains to child custody?
No, for one, my client submitting himself to jurisdiction is not the issue. This isn't a jurisdictional issue, it's a venue waiver issue.
Submitting himself to the venue of Wake County.
Correct, but submitting yourself to the venue of Wake County means the waiver analysis under Lending Tree. And I would submit that if you read Lending Tree and you read the specific facts and circumstances that led to waiver there, I mean, go down the list. Everything is the exact opposite here as it was Lending Tree. The only similarity is that there was a substantive response pleading filed there and here. In that case, there wasn't anything saying that that was even a consideration. Judge Dietz didn't even mention it. And so, and remember, it's a totality test. I've got a little time, but to wrap up, it's a totality test. Lending Tree didn't need to see much in support of the second factor because there was a whole lot in support of factors 1 and 3. There was a 3-year delay in hearing the venue motion in that case. Your Honors, have any further questions? I see my time is up.
Thank you for your arguments, and we will take it under advisement. All right.